Please be seated. The sitting is open. For reasons duly made known to me, Judges Tomka and Yusuf are unable to sit with us today. The court meets this morning to hear the second round of oral argument of Armenia on the preliminary objections raised by the respondent in the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan. I shall now give the floor to Mr. Konstantinos Salonidis. Sir, you have the floor.
Mr. President, Madam Vice President, distinguished members of the Court, I will begin Armenia's second round submissions by responding to Azerbaijan's arguments on Wednesday regarding the negotiation precondition. I will briefly make 3 points. Turning to the first point, the Council for Azerbaijan on Wednesday admitted that the Court has never excluded what he calls pre-negotiations from the concept of negotiations. But he argued that such exclusion should be, in his words, the logical consequence of the Court's definition of negotiations. In support of this argument, Council stated, I quote, "In Georgia versus Russia, the Court held that negotiations require that the subject matter of these discussions must relate to the substantive obligations under CERD. But that is not what the Court said. I invite the Court to closely review the Wednesday transcript, which is now on your screens, with the passage I just highlighted in yellow. As the transcript makes clear, only the phrase substantive obligations under CERD falls within quotation marks. The remainder is Council's own representation of the Court's views. Now on your screen is the paragraph from Georgia versus Russia that Council cites. It reads in relevant part, I quote, "In the present case, the Court is therefore assessing whether Georgia genuinely attempted to engage in negotiations with the Russian Federation with a view to resolving their dispute concerning the Russian Federation's compliance with its substantive obligations under CERD. So what matters is not that each and every discussion between the parties directly concerned the substantive obligations, but rather that the negotiations were conducted with a view to resolving the dispute concerning the substantive obligations under CERD. And I would be remiss if I did not point out how distant we are from the facts of Georgia versus Russia and the questions they posed about whether the CERD had even been the subject of discussions in the first place. The Court's definition of negotiations that supports Armenia's position that what opposing counsel has referred to as pre-negotiations should not be excluded from the concept of negotiations, as long as they are conducted with a view to resolving the dispute concerning the substantive obligations under the CERD. And there can be no dispute that all of the parties' exchanges that Armenia has put on the record were made with a view to resolving the dispute concerning Azerbaijan's substantive obligations under the CERD. As I mentioned on Tuesday, the Court's jurisprudence in fact supports affirmatively Armenia's position. Azerbaijan had no response to this on Wednesday. As I also mentioned on Tuesday, Azerbaijan's own pleadings in the Azerbaijan versus Armenia case did not distinguish between pre-negotiations and negotiations. Azerbaijan had no response to this either, instead pointing to alleged important differences with an application filed a mere week after Armenia's. And as I further mentioned on Tuesday, Azerbaijan's position would enable a respondent to invade the Court's jurisdiction under Article 22 by repeatedly raising procedural and technical matters and delaying agreement in that regard, after having pro forma declared its alleged willingness to negotiate. Azerbaijan once again provided no response to this point on Wednesday. Moreover, as the court emphasized in Ukraine versus Russia, the third requires state parties to eliminate racial discrimination without delay and emphasizes the need to do so speedily. The court, for this reason, among others, found Article 22 to impose alternative rather than cumulative preconditions. For the same reason, Article 22 should be interpreted so as not to exclude pre-negotiations when they are made with a view to resolving the dispute, especially when they are being imposed as a condition before any substantive discussion may begin, as was the case here. Otherwise, again, respondents could undermine the speedy elimination of racial discrimination. To conclude on this point, Mr. President, all of the exchanges between the parties were made with a view to resolving the dispute. As such, they all qualify as negotiations for purposes of Article 22. I now turn to my second point regarding the context of negotiations. Azerbaijan asks you to consider as relevant context that the parties had not been on speaking terms. The parties' mutual distrust, however, did not preclude their ability to engage in direct negotiations, nor would it have precluded resolving the dispute if Azerbaijan had any genuine interest in doing so. But the negotiations demonstrated ultimately that there was no reasonable probability of a negotiated settlement. And this is even more so considering the constant aggravation of the dispute by Azerbaijan throughout the course of the negotiations. Azerbaijan argues in that regard, I quote, "Urgency has no bearing on the jurisdictional requirement under said." But it is very telling that Azerbaijan had no response to the merits of our argument on Wednesday. And since Azerbaijan agrees that the context of negotiation matters, there is no a priori reason to exclude factors such as the urgent risk of irreparable prejudice to rights enshrined in the Convention. This brings me to my third and final point, which is that the negotiations had manifestly become futile by the time Armenia filed its application. Indeed, many of the exchanges that Council for Azerbaijan labels as pre-negotiations were not, as Azerbaijan claims, limited to procedural and technical matters. As I mentioned on Tuesday, starting from its very first letter, Armenia repeatedly asserted its substantive claims, and Azerbaijan, starting from its very first letter, repeatedly rejected them. Moreover, Armenia did consider Azerbaijan's proposals for 2 weeks and explained in the 15 September 2021 meeting why they were not acceptable to it. The negotiations here were thus not unlike those in Ukraine versus Russia, where the court found the preconditions satisfied. What matters the most, as the court noted in the Qatar-ICAO appeals cases, is that there is no reasonable probability that further negotiations would lead to a settlement, and that was unquestionably the case here. On Wednesday, Council for Azerbaijan highlighted one specific alleged proposal by Azerbaijan. I quote, "Acknowledge that the use of mannequins to depict Armenian soldiers in the military trophies park inflamed tensions between the two states. But I respectfully invite the court again to review the transcript closely. There are 2 strategic ellipses in this passage. The relevant text from Azerbaijan's proposal is as follows. Acknowledge that the use of mannequins to depict Armenian soldiers in the military trophies park in Baku and ongoing operations in Armenia by certain hate groups have inflamed tensions between the two states." And it goes on. Here is the next sentence. "On this last point, I should note," Azerbaijan says, "that these 2 issues are not comparable. The park memorializes the servicemen who were lost in the war and commemorates the liberation of Azerbaijan's territory, after almost 3 decades of unlawful occupation and was never intended to incite anti-Armenian hatred. Professor Murphy showed you on Tuesday what the park in fact memorializes. But for my purposes, Mr. President and distinguished members of the court, this statement by Azerbaijan was decidedly not a proposal for the amicable settlement of this dispute. It was yet another assertion by Azerbaijan that it is right and Armenia is wrong. For all those reasons, Azerbaijan cannot reduce to a molehill the mountain of negotiations between the parties in this case. Armenia respectfully submits that the negotiation precondition was satisfied, such that Azerbaijan's first preliminary objection must be rejected. Mr. President, this concludes my remarks. I would kindly ask that you give the floor to Professor Karzan to continue Armenia's pleadings.
I thank Mr. Salonidis for his statement. J'appelle maintenant à la barre, Monsieur le Professeur.
I would not like to call Professor Pierre D'Argent to make his presentation. Thank you, Mr. President. Members of the court, I will confine myself to making just 3 brief introductory remarks on the presentations made by my colleagues. First remark, the points of convergence. At the end of the hearings, the parties agree on the legal tests applicable to rule on the Ratione materiae objection raised by Azerbaijan pertaining to Armenia's request number 245. These are claims made in the 9th part of its memorial devoted to submissions. Parties also agree that the convention applies to armed conflict. Furthermore, Azerbaijan has not contested, 1, that ethnic Armenians were a protected group under the convention, that 2, Armenia's allegations to which it objects concerns cases of direct discrimination and not indirect discrimination by effect, 3, that a difference in treatment based on a ground prohibited by the Convention continues to fall within its scope, even if other grounds not covered by the Convention also exist. And 4, that the same facts can constitute breaches of obligations contained in distinct legal instruments. And then 5, that the Convention does contain legal obligations put forward by Armenia to substantiate its claims. Second remark, although Azerbaijan maintains that at this stage Armenia's evidence should be taken as it stands on their face, its second preliminary objection asks you in reality and in every respect to weigh the evidence, to analyze it, to the point that you have to reject it as being insufficient. If it is insufficient now, it will necessarily be insufficient at the merit stage, even in support of other claims that are not the subject matter of any preliminary objection. So what Armenia is asking you to do is totally inappropriate at this stage. Armenia requests the court to examine all the evidence for what it is, so as to draw its own conclusions in order to ascertain if the claims that are the subject matter of the preliminary objection are likely to constitute discriminatory practices that violate the Convention. Third remark, as Azerbaijan has declared at the preliminary objection stage, the threshold for jurisdiction Ratione materiae to be established is low. It's a low threshold. Furthermore, as Armenia has acknowledged, and I have also recalled it, the Convention applies in the case of armed conflict. So having no way out in the face of the facts put forward by Armenia, and since it was no longer in a position to contest that the obligations relied on by Armenia to support its claim did indeed fall within the Convention, Azerbaijan has attempted to create confusion and has pulled off a 3-stage sleight of hand. At first, Azerbaijan showed itself to be reasonable. It belatedly amended its Ratione materiae objection. So Armenia's second claim pertaining to abuses committed against ethnic Armenians was chopped up based on two distinctions having no basis in the Convention. On the one hand, distinctions between abuses between armed forces and civilians. On the other hand, distinctions between the periods of active hostilities and other periods. The Ratione materiae objection is thus made up of a Ratione temporis layer and a Ratione personae layer. Is that any clearer? Certainly not. But you see, that is exactly Azerbaijan's aim. Furthermore, the additional requirement of specific evidence purportedly indicating misconduct capable of falling within cert, this additional requirement applies without justification only to civilians, thus subliminally giving you the impression that no evidence is supposedly necessary or exists in the case of armed forces, in the case of arbitrary detentions or enforced disappearances, while the evidence that does exist for civilians was supposedly insufficient right from the outset. Secondly, in talks about talks style that are supposedly not negotiations, Azerbaijan argues that hate speech and incitement to hate are not what they are. That President Aliyev knows better than those listening to him what he wants to say. That seems like a reasonable proposal. It is well known, isn't it, that on the battlefield, language is made up of subtle distinctions. So words such as your kind, or your sort, or your type do not mean your race, and that these words do not denote any distinction or any contemptuous classification of the poor ethnic Armenian trembling and begging for his life. That's very obvious. Therefore, no distinction was made that is likely to be based on a ground prohibited by the Convention, and the gratuitous senseless violence unleashed was timidly acknowledged as being horrific and disgraceful and racially sanitized. Or rather, I quote, "It is not racially motivated violence in the way that is being portrayed by Armenia." End of quote. This violence is not racially motivated, at least not in the way Armenia suggests. And it's true, when it comes to racial violence, it is all in the way. Racism is not racism. Evidence is not evidence. Or even if it is, it doesn't reflect the same thing as Armenia claims. And that is obvious to one and all. Or that this evidence is insufficient. Not only is all this nauseating, all this also is imperceptibly trying to obtain a negative judgment from the court, or is attempting to pre-orient the discussions of the merits regarding evidence, also concerning claims that are not part of any preliminary objection. This is very inadequate at this stage, and I think that the court knows very well what it needs to do, and therefore I will say no more. Thirdly, Azerbaijan has pulled a scarecrow out of its magician's hat. Armenia's claims are supposedly, and I quote, "an unrecognizable and unmanageable series of entirely open-ended claims covering all allegations of unlawful violence against combatants or civilians in the active hostilities phases of an armed conflict." Here we go again. And on top of that, this time there's a shoehorned argument. To agree to your Armenia's claim would open the court's doors without limits. It would denature the convention. It would allow all armed conflicts and future wars that will tear humanity apart to be brought before the court in their entirety under the guise of the convention. Mr. President, members of the court, it is totally wrong to suggest that Armenia has submitted all aspects of the armed conflict between the parties to the court. Most of the military operations during the 44-day war and other previous clashes are not the subject matter not the subject matter of Armenia's request in any way and are not described in its memorial. Armenia has never contended that military losses inflicted on it by Azerbaijan during operations and military engagements in compliance with IHL 4 under the convention merely due to the ethnic origin of its victims, of its loyal combatants. It has never been the case and it will never be Armenia's claim. There was quite a bit of talk about prisoners of war. Armenia, in this case, is not claiming that Azerbaijan held prisoners of war, and it's not complaining about that. What Armenia is complaining about is that Azerbaijan did not take prisoners of war when it should have, and that instead its armed forces shot poor ethnic Armenian combatants down like dogs outside of combat. Or that after taking them prisoner, Azerbaijan mistreated them during their detention or held them well after cessation of hostilities or made them disappear again long after the active phase of hostilities. And Armenia contends at this stage of the proceedings, given the specific nature of this bitter ethnic conflict, given the hate speech spread at all levels of power and in Azerbaijan society, and given all the specific evidence provided in its memorial, and recalled by my colleagues that these claims, as Armenia suggests, were indeed likely to constitute breaches of the convention, irrespective of whether these facts might also be unlawful on another ground. I will now turn to allegations relative to indiscriminate bombing of civilian residential areas using cluster bombs and other indiscriminate weapons against the civilian population. Azerbaijan considers that claims related to these facts do not fall under the provisions of the Convention. Armenia believes, on the contrary, that the deaths that occur during these indiscriminate bombings and that are largely documented are perfectly capable of constituting discriminate differential treatment prohibited by the Convention. Why? Because the areas targeted indiscriminately and without any military objective were exclusively populated with ethnic Armenian civilians. Because when Azerbaijan wants to attack in a discriminate manner Armenians' identity, that is to say its cultural heritage, it also does so deliberately and without the slightest hesitation. Evidence of this has been known to the court since the first hearing for the indication of provisional measures. I would like to recall that the cavalier declaration made by President Aliyev to BBC that the double bombing of the Saint Gazan-Shatsos Cathedral of Sushi could have been accidental was proven wrong following ballistic analysis. Because massive attacks on the civilian population had been announced at the highest level as part of a strategy. You can see it as a footnote of our memorial, that it was part of a deliberate strategy aimed at terrorizing ethnic Armenians, because in fact these attacks took place against a backdrop of racist discourse. Now, wouldn't all this constitute violence based on a distinction on a ground prohibited by the Convention? Madam, members of the court, I think that one would have to be blind not to see this and deaf not to hear this. Mr. President, members of the court, Madam Vice President, thank you very much for your attention, and with your permission, I would now like to ask Professor Mercy to make his presentation.
Sir Sean Murphy, the floor.
Je vous remercie, Monsieur le Président. I will address 2 points that cut across all the claims that are the subject of Azerbaijan's second objection. The first point relates to the irrelevance of international humanitarian law, or IHL, to this phase of the proceedings. As Professor Dargent has just explained, there remains considerable confusion with respect to the scope of Azerbaijan's second objection. On the one hand, Mr. Wordsworth assured us that there is no cynical plot afoot. And he says, Azerbaijan is not, of course, saying that anything goes on the battlefield so far as SURD is concerned, or that SURD is somehow displaced by the rules of international humanitarian law. But on the other hand, what does Azerbaijan say in its reformulated submissions, which appear at the bottom of your screen? It says that any acts of murder, torture, and inhumane treatment of members of Armenia's armed forces during the active hostilities phase of armed conflict are incapable of violating the SURD. Forgive us for not being able to square that circle. Given that Mr. Wordsworth defines the active hostilities phase of armed conflict as covering the entire Nagorno-Karabakh war, as well as other open-ended dates, then it certainly looks like Azerbaijan wants the court to find, at least for this case, that anything goes on the battlefield so far as SURD is concerned. Civilians don't fare much better under Azerbaijan's reformulated submissions. They, too, cannot be protected during hostilities by the SURD unless there is specific evidence that indicates misconduct capable of falling within the SURD. One might ponder why a difference is even being drawn between soldiers and civilians. They're both protected persons under IHL and under the SURD, and they were both murdered, tortured, detained, and disappeared in very similar ways. Why is one group completely off the table for the court's jurisdiction, while the other stays on the table so long as the table is properly set? Now, one possible interpretation of Azerbaijan's position is that they have carefully reviewed every single piece of evidence relating to violence against soldiers, and not a single one is capable of demonstrating racial animus, while for civilians, there may be such evidence. I'll leave it to Ms. McDonald to dispel that argument. But another possible interpretation of Azerbaijan's position is that there is something about violent acts against soldiers that, at least in this particular conflict, can only be explained as generalized antipathy between belligerent states, and can only be explained as understandable animosity between two states that have experienced the tragedy of war. On this interpretation, the tragedy of war in this particular conflict has displaced the SURD when it comes to acts of violence against soldiers, and moreover displaced the SURD when it comes to all acts of detention and enforced disappearance. Professor Boisson de Charzon was candid in taking this position when it came to detention, citing specifically to the Third and Fourth Geneva Conventions. Yet arguing that IHL displaces the SURD when it comes to detention is problematic, given that IHL itself requires treating prisoners of war and civilian internees, quote, without any adverse distinction founded on race or any similar criteria, end of quote. Indeed, the prohibition on racial discrimination cuts across both fields such that there is no lex specialis. Similar to the relationship between IHL and the International Covenant on Civil and Political Rights, both spheres of law are complementary, not mutually exclusive. In any event, if we are going to get into questions of whether there is a lex specialis on particular issues such as repatriation that relate to particular facts, such as whether the prosecution of a specific POW is allowed under IHL, then that is clearly an issue for the merits, where both sides can marshal the facts and law as they wish. For present purposes, the only issue is whether the alleged conduct concerning detention is capable of violating the CERD, which surely it is. However one might understand Azerbaijan's position, Mr. President, Armenia stands by its submissions from Tuesday. It is common ground between the parties that in situations of armed conflict, the applicability of IHL does not preclude the application of the CERD, which operates independently. The court has said this, and the CERD committee has said this. And such reasoning is consistent with the court's view that certain acts or omissions may give rise to a dispute that falls within the ambit of more than one treaty. Given the evidence that we have submitted, the claims to which Azerbaijan objects are capable of violating the CERD regardless of any connection to IHL. And as a final point on this issue, if Azerbaijan's position is that claims concerning soldiers and civilians during the so-called active hostilities phase of armed conflict fall entirely or largely outside the CERD, then that position is certainly in tension with the court's prior findings on plausibility in its provisional measure orders in this case. That there were IHL implications to the conduct we allege was well known to the court right from the start of this case. But the court did not see IHL as an obstacle when finding it plausible that CERD rights were at issue concerning soldiers and civilians caught up in hostilities. Mr. President, members of the court, I turn to my second point, which is that Azerbaijan cannot avoid the implications for this jurisdictional phase of the widespread ethnic hatred that it promotes and condones. Azerbaijan's principal gambit on Wednesday seems to have been
process violations Armenia has presented. On Wednesday, Azerbaijan could largely only repeat its previous arguments, not just from Monday, but also from more than 2 years ago. In particular, Azerbaijan claimed that its judicial system is not discriminatory against ethnic Armenians because it allegedly refused to uphold charges against Armenian detainees, dropped charges against them, or commuted their sentences. But while Azerbaijan has occasionally released prisoners who were convicted while refusing to commute the sentences of others who were captured in the same place and convicted of the same crime, if anything, that merely underscores that ethnic Armenians have been arbitrarily detained. Azerbaijan also stated that trials against ethnic Armenian detainees took place in open court, in the presence of representatives of the ICRC, the Diplomatic Corps, the Azerbaijani Ombudsman, and the international media. These factual assertions were recycled from Azerbaijan's presentation during the oral proceedings on provisional measures in October 2021. Azerbaijan's October 2021 presentation also referred to the same legal provisions of Azerbaijan's criminal procedure code that it placed in your folders on Monday to show that it respects due process. But Azerbaijan could not convince the court at that stage that it was guaranteeing ethnic Armenians fair trials and due process, which is why the court ordered Azerbaijan to, quote, ensure their security and equality before the law. Azerbaijan's counsel also referred to the trial and conviction of Mr. Vikin Yuljekshian, claiming that Armenia was wrong to assert that he was a civilian. To be clear, at the time of his detention, Mr. Yuljekshian was a civilian. He was captured after the conclusion of the trilateral statement with another civilian while driving in a personal car from Lachin to Shushi to collect his belongings. The fact that he allegedly previously posted undated photos of himself carrying military equipment does not change this. Much less does it change the fact that he was convicted of serving as a mercenary despite being an Armenian national. On Wednesday, we heard nothing about this conviction at all. Mr. Yuljekshian remains behind bars as I speak, convicted of a crime that he confessed to under, quote, apparent duress, and that Azerbaijan has not even attempted to defend before this court. In contrast, we did finally hear from Azerbaijan with respect to Armenia's claim concerning the numerous ethnic Armenians who were not Armenian citizens and were detained at Azerbaijan's ports of entry, merely because they had Armenian surnames. The members of the court will recall that Azerbaijan offered no response to this aspect of Armenia's claim in its written observations or in its oral submissions on Monday. Azerbaijan's primary response, when it finally addressed the issue on Wednesday, was to rely on quotes made by its president in a speech after proceedings in this case were instituted, claiming that Azerbaijan allows ethnic Armenians to enter the country. Of course, whether or not Azerbaijan has occasionally admitted ethnic Armenians to its territory is not the question. The question is whether Armenia has put forward evidence that is capable of establishing that Azerbaijan has arbitrarily detained ethnic Armenians at its ports of entry in violation of the CERD. And that, we respectfully submit, Armenia has plainly done. We refer the court to pages 130 to 136 of Armenia's memorial. Among the evidence cited there, the court will see that relating to an Estonian citizen of Armenian origin who arrived in Baku to participate in a conference alongside other Estonian officials. Although she had officially received an electronic visa, she was held in the Baku airport for 12 hours and then sent back to Estonia by the Azerbaijani authorities after they, quote, noticed their mistake and her, quote, Armenian background. Is any of this ethnic discrimination surprising? No, it is not. In the words of the head of the press service of Azerbaijani Railways, quote, the entry of ethnic Armenians who are nationals of other countries is officially prohibited. Are these just routine identity checks carried out by border guards or customs authorities, as Azerbaijan claims? No, they're not. They are, on their face, blatantly racist detentions carried out on the basis of their victims' ethnicity alone. On Wednesday, Azerbaijan also addressed, for the very first time, the fact that it had not objected to Armenia's separate claim that Azerbaijan has failed to guarantee equal treatment by its justice system. As Armenia explained on Tuesday, if Armenia's claims of unequal treatment in its justice system fall within the CERD, then Armenia's claims of discriminatory detention predicated on unequal treatment in the justice system must fall within the CERD as well. How did Azerbaijan attempt to circle this square? By claiming, for the first time, that it objects to aspects of the court's jurisdiction over Armenia's separate claim concerning Azerbaijan's failure to guarantee equal treatment by its justice system as well. Of course, On Wednesday, Azerbaijan's counsel made no mention of the fact that her colleague had stated, just minutes before, that Armenia's claims concerning the, quote, withholding of civil and political rights are, quote, recognizable as matters capable of falling under the SIRD. Nor did Azerbaijan's counsel mention the fact that Armenia's claims of unequal treatment of ethnic Armenians by Azerbaijan's judicial system include claims concerning the withholding of civil rights. Can it really be said that Armenia's claims of unequal treatment of ethnic Armenians by Azerbaijan's justice system fall within the SIRD except where they concern ethnic Armenians who have been arbitrarily detained? Once again, Azerbaijan has not offered any reason why the court should accept such a counterintuitive point. Azerbaijan's counsel finally claimed on Wednesday that the court cannot rely on so-called reports of general content, which do not constitute first-hand evidence. Well, counsel did not identify which reports she meant, but many of the reports I referred to on Tuesday were based on interviews and first-hand testimonies of returned ethnic Armenian detainees. They are very much reliable for that reason alone. This concludes my presentation. I thank you once again, Mr. President and members of the court, for your kind attention, and I ask that you call Professor Sicilianos to the podium.
I thank Mr. Klinger for his statement. I now invite Professor Linos Alexander Sicilianos to take the floor. You have the floor.
Mr. President, Madam Vice President, distinguished members of the court, I shall present Armenia's rebuttals on the third and last strand of Azerbaijan's Ratione materiae objection, namely Azerbaijan's objection to Armenians' claims concerning Azerbaijan's enforced disappearances of ethnic Armenians. I shall also offer some comments on the importance and relevance for the present proceedings of the concluding observations of the third committee and of the findings of other UN human rights bodies and special rapporteurs, which has been challenged by Azerbaijan's presentations in the last few days. Azerbaijan cannot dispute that the prohibition of enforced disappearance is encompassed within Article 5's broad and non-exhaustive guarantee of the equal enjoyment of all human rights. The prohibition of enforced disappearance is a rule of customary international law, if not jus cogens, and when it involves racial discrimination, it breaches the third. Azerbaijan cannot dispute the concrete evidence that Armenia has presented concerning both servicemen and civilians of ethnic Armenian origin who are believed to have been in Azerbaijan's custody and have either been murdered without the circumstances of their death acknowledged by Azerbaijan or remain missing until today. To be clear, with respect to both categories of enforced disappearances I just mentioned, Armenia refers specifically to those who are known to have been in Azerbaijan's custody, contrary to what Professor Boisson de Chajourne suggested. Moreover, Armenia has also put forward clear evidence that Azerbaijan has repeatedly obstructed searches for and repatriation of the remains of ethnic Armenians in territories under its control. In this regard, Azerbaijan repeatedly relied on its repatriation of more than 1,700 bodies to Armenia following the 44-day war, but does not explain why this is relevant to those ethnic Armenians who were last known to be in Azerbaijan's custody, but whose fates remain unknown today. Finally, Armenia's evidence shows that Azerbaijan has also concealed the fates of ethnic Armenians who were forcibly disappeared following the submission of Armenians' memorial. Counsel for Azerbaijan did not contest such evidence. Mr. President, what is striking is Azerbaijan's complete failure to challenge the palpable ethnic element of discrimination in all the above cases, many of which are documented by video footage. That element is even more visible in numerous cases of completely inoffensive civilians, including elderly people up to 90 years old and persons living with disabilities, who were the last to flee due to their age and yet were subjected to enforced disappearance by Azerbaijan. Again, Council for Azerbaijan did not give any explanation how the subjection of these individuals to enforced disappearances could be based on any grounds other than ethnic hatred. Yet Azerbaijan somehow claims that there is no specific evidence of differential treatment based on ethnic origin concerning Azerbaijan's practice of enforced disappearance of ethnic Armenians. To be clear, the question whether there is a practice or practices of enforced disappearances based on existing evidence is an issue to be examined at the merits. This is therefore a transparent attempt to deflect from the weaknesses of Azerbaijan's objection at this stage and the central issue to the court's consideration, namely the ethnic dimension that Armenia has amply shown. I come now to my second point, namely the relevance and importance of Third Committee concluding observations and findings of other prominent UN experts and special rapporteurs. Armenia has extensively invoked the findings of the Third Committee in its concluding observations of 2022, in which the committee examined almost all claims of Armenia in its memorial concerning a period including the 44 Days War. Yesterday, we heard from Professor Boisson de Sajourne that such concluding observations should be disregarded by the court. Comme il a été mentionné lundi dernier, les observations du dit comité ne sont pas d'assistance à la Cour afin d'établir sa compétence en vertu de la sièdre. This is in stark contrast with the opening statement of Mr. Mamadov, the agent of Azerbaijan in this case, in Geneva in 2022, during those same committee proceedings which resulted in the adoption of the aforementioned concluding observations. I quote Mr. Mamadov, "We highly appreciate the dialogue with the committee, which significantly contributes to our efforts for overcoming existing challenges and making further progress. The Republic of Azerbaijan considers the interactive dialogue with the committee as a significant mechanism for monitoring and reviewing actions taken by the government to fulfill its obligations under the Convention." End of quotation. As it is well known, the concluding observations of UN human rights treaty bodies in general, and of the Third Committee in particular, are the corollary of the whole process of examination of states' reports, which includes a 6 hours constructive dialogue with the state delegation and considers a broad range of contributions by a variety of independent stakeholders, including other international bodies and institutions, as well as NGOs contributing first-hand information and testimonies. It is true that the concluding observations are not judicial decisions. They are adopted in a specific framework, and as Mr. Mamadov observed, they claim at helping states to fulfill their commitments under the Convention. However, when a committee expresses deep concern about a series of acts or omissions of the state under examination, as the Third Committee did in relation to Azerbaijan in 2022, this is a very alarming sign addressed to the state in question based on multiple converging sources. The court places high importance on UN treaty bodies' findings of facts and law in its judgments and advisory opinions. As the court explained in relation to the Diallo case, although it is in no way obliged in the exercise of its judicial functions to model its own interpretation of the Covenant on Civil and Political Rights on that of the Human Rights Committee, it believes that it should ascribe great weight to the interpretation adopted by this independent body that was established specifically to supervise the application of that treaty. Similar considerations apply to the other treaty bodies, including the Third Committee. Let me recall the main findings of the Third Committee concluding observations in relation to the preliminary objections of Azerbaijan, which you can see on your screen. The Committee is deeply concerned about allegations of severe and grave human rights violations committed during the 2020 hostilities and beyond by Azerbaijani military forces against prisoners of war and other protected persons of Armenian ethnic or national origin, including extrajudicial killings, torture, and other ill treatment and arbitrary detention. The invitation to the Court to simply disregard the findings of the specialized treaty body on issues of racial discrimination concerning a significant part of the period and context related to Armenia's application is most surprising. Azerbaijan is inviting the Court to consider that the findings of the Third Committee do not even pass the threshold of the preliminary stage of proceedings. This would constitute a serious blow to the authority and credibility of the Third Committee and to the UN treaty body system more generally. All the more so that the above approach by Azerbaijan could be applied mutatis mutandis to the statement at tab 5 of your judges folder from Tuesday, emanating from two special rapporteurs, the chair rapporteur, and 4 other members of the working group on enforced or involuntary disappearances, all democratically elected by the Human Rights Council, which you can see on your screens. May I recall that special rapporteurs and working groups are part of what is known as special procedures of the Human Rights Council, that is the largest body of independent experts in the UN human rights system, constituting independent fact-finding and monitoring mechanisms that address either specific country situations or thematic issues in all parts of the world. The above-mentioned statement covers not only enforced disappearances, but also extrajudicial killings, torture, and other ill treatment against ethnic Armenians during and in the aftermath of the 44 days war, as you can see on your screens. Joint statements of this kind are relatively rare in UN practice, and they concern only egregious violations of human rights. Azerbaijan's logic of summarily disregarding such statement would inflict yet another blow to the UN human rights protection system. By way of conclusion, let me reiterate that the enforced disappearances of ethnic Armenians fall within the scope of application of the Third. This claim is corroborated by the findings of the Third Committee, as is the case with all of Armenia's claims which have been the subject of Azerbaijan's preliminary objections. The same observation goes mutatis mutandis for the findings of the UN Special Rapporteurs and the members of the UN Working Group on Enforced or Involuntary Disappearances. Mr. President, members of the Court, this concludes my presentation. I thank the Court for its kind attention, and I kindly ask you, Mr. President, to call upon the agent of Armenia, His Excellency Mr. Kyriakosyan, to present Armenia's final submissions. Thank you very much.
I thank Professor Sicilianos for his statement. I now call upon the agent for Armenia, His Excellency Mr. Kyriakosyan. You have the floor, Excellency.
Mr. President, Madam Vice President, members of the Court, it is an honor to appear before you once again this week. I will be brief. This week, Azerbaijan failed to respect the clearly circumscribed limits of the preliminary objections phase. It disregarded the legal standards clearly established by the Court's jurisprudence, and it distorted Armenia's factual evidence. But Azerbaijan's tactic has failed, its stance is not conducive to good administration of justice. As Armenia's Learned Council demonstrated this week, Armenia genuinely attempted to negotiate its claims under the CERD, but to no avail. Armenia thus fully complied with the negotiation precondition of Article 22 of the CERD. Moreover, all of the Armenia's claims fall squarely within the material scope of the CERD. Azerbaijan's racist violence, arbitrary detention, unenforced disappearances perpetrated against ethnic Armenians are plainly capable of falling within the CERD. As you saw this week, these horrific practices are anathema to promise undertaken by all state parties to the CERD to, and I quote, adopt all necessary measures for speedily eliminating racial discrimination in all its manifestations and forms, and to prevent and combat racist doctrines and practices in order to promote understanding between races and to build an international community free from all forms of racial segregation and racial discrimination. End of quote. The course has before it all the necessary elements to easily dispense with Azerbaijan's objections. Armenia looks forward to continuing its pursuit of accountability in the proceedings on the merits, and reconfirms its dedication to resolve this dispute peacefully and in a manner that honors both the letter and spirit of international law. In accordance with Article 60, Paragraph 2 of the Rules of the Court, I will now read out the Republic of Armenia's final submissions. The Republic of Armenia respectfully requests that the Court, A, reject the first preliminary objection raised by Azerbaijan, and B, reject the second preliminary objection raised by Azerbaijan, or, in the alternative, decide that Azerbaijan's second preliminary objection does not possess an exclusively preliminary character. Before concluding, I wish to express my gratitude to the Registry and its staff for their kind assistance in these proceedings, to the interpreters for their hard work, and finally, Mr. President, members of the Court, thank you for your attention and serious consideration of the parties' submissions this week hearings. Thank you.
I thank the agent of Armenia for his statement. The Court takes note of the final submissions which you have just read on behalf of your government. Ainsi s'achève la présente série d'audiences. Je tiens à remercier les agents, conseils, avocats des deux parties pour leurs interventions. Conformément à la pratique habituelle,
I shall request both agents to remain at the Court's disposal to provide any additional information the Court may require. With this proviso, I declare closed the oral proceedings in the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan, on the preliminary objections raised by the respondent. The Court will now retire for deliberation. The agents of the parties will be advised in due course as to the date on which the Court will deliver its judgment. Since the Court has no other business before it today, the sitting is declared closed.